Good morning. Today we are going to discuss about the elements of torts. There are three basic elements of tort. The first is a wrongful act, the second is damage, the third is the remedy. These three elements we are going to discuss today. The first element in tort is what? Wrongful act. In the first video of tort itself, I have told you there must be a wrongful act. There must be some wrong. If wrong is not there, tort is not there. Therefore, some wrongful act must be there. A wrong can be divided into a legal wrong and a moral wrong. We are not concerned here about moral wrongs. We are here concerned about the legal wrong. In the definition itself, it is mentioned that breach of a duty fixed by law. What is a tort? A tort is a breach of duty fixed by law. Therefore, what is a wrong? Which law has stated that okay, you have done here wrong because the rights are violated of other person. You have done some breach of duty which law has fixed. Therefore, there must be some wrongful act. Wrongful act which is legally recognized. Therefore, we call here it as a legal wrong. There must be some legal wrong. Then only a tort is there. If everything is going on okay, everything in a proper time and proper place, there is no wrong. Therefore, a legal wrong is a wrong which is fixed by law. It is clearly stated and recognized by law, and that wrong the person has done, the tortfeasor has done. Therefore, there must be a wrongful act. Now, this wrongful act is going to affect the rights of the plaintiff. Therefore, the plaintiff will come to the court. Okay, therefore, the first element is very much clear. There must be some wrong, then only tort is there. The first element is wrongful act. The second is there must be some damage. Now, in tort, damage and damages are different. Damage means loss, some loss, some you can say monetary loss, some hurt, some injury, physical injury. That is called as a damage. While damages is called as a compensation, a pecuniary compensation. Therefore, the second element is damage. Now, for explaining, for understanding what exactly damage is required in law, we are having two maxims, damnum sine injuria and injuria sine damnum. The first we are going to see is damnum sine injuria. Damnum means damage, sine means without, injuria means legal injury. Damnum, damage without legal injury, means damage without legal injury. Here, the plaintiff has suffered some damage, some loss, but he has not suffered any kind of legal injury. And therefore, law says if legal injury is not there, then that is not a tort. You should not come to the court. You will not get compensation. You are not the right person to come to the court because there is no legal injury. Therefore, law recognizes legal injury and not just loss, not just damage. That has been told by this maxim, damnum sine or sine injuria. Damnum sine injuria means damage without legal injury. For this, I will tell you the famous case of Gloucester Grammar School case. Gloucester Grammar School was a famous school, a flourishing school. Many students used to go there. Therefore, that person's rival, he doesn't want to do something in school and for education and all, just for rivalry purpose, just to reduce some students from this school, he started another school, his own school, just nearby Gloucester Grammar. Therefore, what happened? Some of the students in the coming year, they went to the new school. Therefore, there was actual damage to Gloucester. We'll take an example. Gloucester used to get some 100 students every year. This time what has happened? Only 80 students have taken admission in Gloucester, while 20 students have gone to that another school. Therefore, you can say that there is an actual damage. 20 students are not there in Gloucester. If this school would not have been there, these 20 students would have taken admission in Gloucester only. Therefore, there is actual loss of 20 students to Gloucester Grammar School. Therefore, the Gloucester Grammar School has filed a case against the rival person that, see, he has started this school, therefore, we are in loss. But this is a case of damnum sine injuria. There may be a loss, but there is no legal injury. The court has held, here you have to enter into fair competition. The other person is having full right to start a school. Though he may have some malice, though he may have some bad intention and all, malified intention, but he is having full right to start another school. Therefore, there is no legal injury. Law recognizes only legal injury, not just damage. This is the first maxim, damnum sine injuria. Now, the second maxim is injuria, just opposite. Injuria sine damnum. Legal injury without damage. Legal injury without damage. Here, law is recognizing, I told you, law is recognizing what? Only legal injury. Law will see damage also, but the main thing law requires is legal injury. Therefore, if legal injury is there, law is going to give you compensation. If legal injury is not there, we can't do anything. We can't give compensation all because no legal injury is there. So, injuria sine damnum means there is a legal injury without damage. Law says, okay, there is a legal injury, na? We are going to give you compensation. We are going to give you solutions and remedy for that. For this, one case is there, which is a famous case. In the previous video also, I have told you about that case, Ashby versus White. This person went for voting. He went there, but the officer didn't allow him. He is called as a rotating officer in books. He didn't allow him to vote. From his side, no wrong was there. Means he is not having certain papers and all. Like that the case was not there. He submitted all the papers, everything. But the rotating officer wrongfully didn't allow him to vote. Now in this case, the person who won the election was the concerned person whom the plaintiff had to vote. Means the plaintiff did not vote at that time, but he did not face any loss because his own contestant had won the election. Means in that way also, like a person has lost by one vote and all, nothing occurred. The plaintiff wanted to vote A won the election, but the plaintiff was not given the right to vote. Therefore, he filed a case. Here, actual damage was not there. Though there is no actual damage, law says, but his legal right of vote is being violated. He has a basic right to vote, and therefore this is a legal injury. As there is a legal injury, we are going to recognize, and therefore he got compensation, though damage was not there. Therefore, the second element in tort is damage in a form of a legal injury must be there. If legal injury is not there, law will not recognize it as a tort. So, two elements of tort we have seen. The first is a wrongful act. The second is the damage in a form of a legal injury. Now, the third important element is remedy. And for this, we follow Winfield's view of thought. And that is, if new wrong occurs, we are going to recognize it because we have to give him justice. The other person, that is a defendant, is not having any kind of justification for what wrong he has done. Therefore, when the plaintiff files a case, though new torts are there, new wrongs are there, law is going to recognize and law is going to give him justice. So legal injury is required. Wherever there is a legal injury, there will be a remedy created by law. This has been depicted by one maxim called as ubi jus, ibi remedium. Wherever there is a right violated, there must be a remedy. Rights and remedy are two sides of one coin. You have to give justice if there is a legal wrong. So we recognize a legal wrong, we recognize a legal right, legal injury, and we provide justice. Ubi jus, ibi remedium. Wherever there is a right violated, wherever there is a legal injury, wherever there is a legal wrong, the person is going to get justice. And only because of the Winfield's theory, we are recognizing new wrongs. Okay, bye bye. See you in the next video.